All right, welcome back. We are here this afternoon with, we're framing this around H391, which is an act relating to creating an eviction diversion program. And I wanted to have this conversation because the concept of an eviction diversion is something that I would like to consider for our work over the next couple of weeks. But there are the way that it's difficult to get I wanted to invite the judiciary, members of the judiciary, and to relate their experiences. I've heard over the past years that there have been things like rent escrow programs where there's been attorneys have come in and helped people who will usually act on pro se basis. Other issues that we've heard about, making it sound like it's a foreign world, even though it's now just across the hall. But we have heard the same thing that we've heard from other places, which is undercapitalized, understaffed, just a lot of unfortunately normal things that relate to the judiciary. But it is a world we know little about in this committee. And when we're trying to discuss eviction diversion and perhaps full representation for tenants in these courts, I wanted to reach out. And so I reached out to Judge Tour, Judge Zone and Terry Corsonas. Just, I don't know how you would like to do this, if you'd like to do it one at a time. But I just wanted to invite you in to give us an idea. I mean, we'll discuss essentially what eviction diversion, the way that we're looking at it. And I just want to pick your brains about what you've experienced in the judiciary, about what do we need? Is this something that's necessary? Is there something that we can do that can make this process? We just heard some very striking testimony from two individuals, one who is threatened with eviction and one who's recently experienced eviction. And it's just one of the conflict points we'd like to make a little bit easier. And we can't do that just with housing policy. We need to do it with other policies such as eviction diversion. I just wanted to get an idea of what it means, not both in actual terms and maybe ask you to imagineer what a better world might be like with the problem that we're trying to solve here. So that's my opening tee up.
You want me to go first?
I think
Sure.
we planned for Judge Tour to give a basic overview and answer questions. We were looking at 391 and responded to that.
Yep.
Is that
Okay, good.
okay?
Where would you like me? Anywhere
In
the hot seat, of course. I'm not used to that.
You want to sit here at the head of the table?
I feel much more comfortable. I'll just pretend this is the head of the table. So, hi, everybody. I'm Judge Tour. Thank you for inviting me. So, first of all, if you do have any questions about sort of the process and how things work, I guess one thing, just background that I should explain that Terry reminded me, is that one of the first steps currently in many eviction cases is a rent escrow hearing. Are you familiar with that process? Am I saying more than I need to?
If you could give us
Okay.
Yeah.
So it doesn't happen in every case, but many evictions, whether it's a non-payment case or not, the landlord has the right to ask for the first step in the case to be a rent escrow hearing. And many people make that request at the same time that they file their complaint. And so we often do have an actual court hearing at the front end of the case that's where the lawyers that you just mentioned, either volunteer lawyers or legal services lawyers, are there because we block schedule them so that lawyers can be there available to help. And in addition, legal services has been reaching out in advance to many of them because they look at the calendar and they contact them in advance. That is pretty much the only place that lawyers currently are part of the process. So I'm going to touch on that in a couple minutes, but that background should help. So I reviewed the proposed statute, and I have, I guess, 5 points to make. So the first one is, although I think mediation as a general principle is a great idea, I'm not sure that it's the solution for non-payment of rent the way this is being proposed. I think it's a great idea for example, what we call cause evictions. Somebody's alleged to be, having a dog that they're not supposed to, or people are living there that shouldn't, or whatever it is. That's where, there's really room to negotiate and say, okay, we'll get the dog out in 2 months. My cousin will move out or whatever it is. The problem with a non-payment, yes.
I'm sorry, just jumping in.
Feel free.
In your experience, is non-payment of rent usually because of lack of funds, or is it
Yes.
because of another issue like dogs or dissatisfaction, or the landlord didn't fix the dishwasher?
So most cases are non-payment. I don't know what the numbers are. Terry or Jean might know that. I'm not sure. But anecdotally, the vast majority of the cases I see are non-payment. So that's where I'm going, is the solution isn't necessarily talking. The solution is having money. And so you can throw all the mediation you want at it, but if you don't have funds to help them pay, the only thing that, you may get what happens sometimes in the negotiations in court, which is, okay, we know we're never going to get the money, but give us more time to leave, or let's come up with a payback plan, but it's going to be, we'll pay $50 a month towards the $5,000, So really having more money, I think, is the key for that. I'm sure you're aware that Legal Aid did this report in 2019. I'm assuming that you're familiar with that report. And, I think it's a great report. I agree with pretty much everything they say. One of the things they said based on their research was that $4,000 or less per tenant would probably resolve 2/3 of the eviction cases, which on their math was about $2 million a year, which is a little more than the money that you have proposed in this statute for mediation. So, my view is, if you have the money, finding a way to put it towards essentially replacing the VRAP funds in a long-term way would be the most effective way to solve the non-payment cases. I also, point two, would strongly make a pitch for trying to find a way long-term to have lawyers to represent tenants. As I said, we have lawyers now at the front end of many cases, but not all. And sometimes there are legal services lawyers or legal aid, I always forget which is which, that represent tenants if they're Section 8 or if there's a disability issue, they're seeking an accommodation. But other than that, they're hardly ever involved in trials. And so they may help at the front end, but then the tenants are there trying to represent themselves at trial with no understanding of how to present evidence, how to get, the housing inspector records. They do get some help sometimes in preparing, but they don't have a lawyer there. This is, if you're interested, there's a term nationwide called civil Gideon, which is the idea, Gideon was the Supreme Court case that said people who may go to jail should have a lawyer provided by the government. That's where the public defender system came from. I feel very strongly, having done mostly civil work in my career, that the fact that someone might spend one night in jail is not more serious than the fact that someone might be kicked out of their housing. And I don't understand why we provide lawyers for one and not for the other. Money probably is the answer, but if we could have the equivalent of a public defender system to represent people who are at risk of losing their housing, I would add also at the risk of losing their children, but that's another issue. We do that in DCF cases, but not in divorce cases. So there's a lot, there are places around the country that do this. San Francisco and New York City have programs like this. I can send you, if you want, some links to some reading if you're interested in that. But I did find one report that said, quote, studies have shown that having an attorney in an eviction case increases a family's chance of avoiding homelessness by over 70%. That's from eviction.defense.org.
So the context for that, I'm just going a little ADD on you and just seeing, so if 70%, if someone has representation and it's helped by 70%, having the $4,000 or $3,000 as a back rent, which is
66%.
shows that it was 66% of that.
I don't know how those two intersect.
Okay, thank you.
Yeah.
Thank you.
I would, just off the top of my head, I would say that if you had the money for the 66%, a good bulk of the other ones would get resolved by having a lawyer, but I have no data to back that
No,
up.
that's fine. It's just this,
Yeah.
the 70% success rate. Please do send us the report.
I will.
And just so that we have it to read, but I think I think understanding through at least the traditional work this committee has done is that 70%, if it's 70% or 65 to 70%, which is purely money alone, why isn't there a public interest, as you were stating with defenders, why isn't there a public interest in reducing the number if we can?
Mm-hmm.
You know, it's not that we're going to accept that 30% of the people are going to be, but they're just harder cases.
Right.
Thank you.
And that, you know, the legal aid report may talk a little bit more, I don't remember, about what that other 33% is. I'm not sure, but I will look at that and see if I can get information for you.
Yeah, we will too.
So I do want to just throw in one thing on the civil Gideon having lawyers. It always raises the issue, if you do go down that path, should you provide a free lawyer to a tenant when the landlord does not have a lawyer? And that's, you know, that's sort of a policy issue. Those tend to be what we'd call the mom and pop landlords who, you know, don't do this for a business and they don't understand the law that much themselves, although some of them are very sophisticated, some are retired lawyers, et cetera. But in my experience, I would say that it actually benefits both parties to have a lawyer for the tenant, even in those situations, because they are able to negotiate resolutions that are good for both sides, that will resolve the case sooner, that will, you know, I think the legal aid report said that one of the counties they studied, when lawyers came in at the front end, they sped up the time frame from 144 days to 88 days when there was a lawyer for the tenant. So just having a lawyer who understands things can make it better for both sides, I think. It is a debate, but I think it's worth considering. My third point is I would love to see something that I think of as one-stop shop for housing information. I mean, there are going to be people who are going to be evicted. And right now, there are two problems. One is there's no housing. The other, and that's my next point, you know, we just need more affordable housing. Everybody who comes into court, a lot of them say, I've been looking for months, I can't find anything. And I know that's true. And I don't know what to say to them except, you know, here's the number for the shelter. But having a place, you know, so there was a brochure at every courthouse and, you know, all the social services places. So everybody got the same information. Here's a number to call. This will get you into the way that VHAP and VRAP have been working. In other words, the housing programs for the COVID money. That's been, you know, one portal that goes in and everybody gets treated through this program the same way. I would love to see a permanent portal like that for everybody who's looking for housing in Vermont so that the resources are all sort of put together. There are people who are skilled at helping people find any funding they can, you know, sign them up for Section 8 or government benefits of whatever sort. I don't know exactly where that would sit, but I think it would be a really helpful idea because now it's, you know, in each county, you know, I say go to COTS because I'm in Burlington, you know, call 211, go to CVOEO, the Champlain Valley, whatever it is. But, you know, in Rutland, we told them go to Brock. There are different things, but it seems to me that having a skilled place to send them would be great. So if you do go with this mediation statute, this H391, I have a few suggestions. One of them is I would not, as I read it now, it essentially kicks in after a notice of termination. And I would recommend that this be available before the landlord gets to that point. If you're going to have a process, you know, it can be months. I mean, we have a lot of landlords who are very nice to their tenants in Vermont. Not all of them, but some of them really, they let them go and they keep, you know, promising and they say, okay, I'll give you another month. And by the time they get to coming to court, you know, it's too late and there's so much money owed and they're angry and frustrated. They may not want to do mediation and it may be hopeless because the amount of money owed is so high. But if there was a place where they could early on say, look, you haven't paid rent in, you know, 6 weeks. Let's go to this mediation process, see if we can come up with a payment plan, see what we can do. I think that would be really helpful to have. So I wouldn't limit it if possible.
Okay. Can you just give us a quick, what are the steps? When we talked last week, you talked there's a 30-day period that used to be 14, but right now it's being interpreted as 30-day period.
For how the court process works?
Yeah, just so that when we're talking about where this fits in the process. So I can't pay my rent. You come and knock on my door and say,
here's a number to call. Will you do mediation with me? And, you know, if this doesn't work, I'm going to have to go to court. That's how I'm thinking of it. So they could have the option of doing it before it got to that point.
And if they filed the notice of termination, then that's when the 30 days comes in?
So it's a little more complicated than that. And just to say, they don't file the notice of termination, they serve it on the tenant, right? They give them a letter saying you must leave by such and such a date. That's the notice of termination, also referred to as a notice to vacate. The time frame they have to give varies depending on the kind of eviction it is. So for cause, no cause, non-payment, all have different timeframes. They even sometimes have different timeframes depending how long the person has lived there, whether they have a written lease or an oral lease. So I'm not going to try to explain it all because I have to go look it up every time because I can't remember. But for the non-payment, the Vermont statute says a 14-day notice. The federal law that came into effect during COVID created a 30-day period for certain non-payment cases that involve anybody who's getting some federal money through a mortgage or their Section 8. It's, again, somewhat complicated. Most people, I think, have at this point interpreted that 30-day requirement still is in effect, although there has been some argument that it ended when the federal COVID law changed. But we're treating it, I think, generally as now you have, if you fit in that category, it's a 30-day notice. And you have to file with the court something saying that, you are or are not within that. And if you are, you gave them 30 days. So I guess I would say it's either 14 or 30. But it's hard to tell until you have more information. Once you give that notice, if the tenant doesn't leave by that date, then you can file in court. And some people don't know and they file before that, but technically you're not allowed to file until the person has had that time to leave and they haven't left. So on day 15 or day 31, you could file in court. You are required to file within 60 days of that date or it's considered too late. Although that's one of those things that, unless the other side raises it, it's not like we don't let them come in the front door, but it's a defense that can be asserted. So this is the other piece. I think that if mediation is happening, there's no reason that it shouldn't be available once they've given that notice of termination or once they filed in court. I think mediation at any time is a great idea. I don't think it should be used to delay the case. Landlords have suffered greatly in the last few years. I mean, many have suddenly gotten big chunks of money eventually, but it was a tough period and the law already has, various steps they have to go through. And I think saying that if you file and then there's mediation, the case should be delayed, to me does not seem fair to both sides, unless they both agree. If they both agree, great. They'd rather work on the mediation piece, that's great. But I don't think it should automatically delay the case. And I did not read the statute as drafted as saying that. So I think that's good. Did I answer your question adequately? Okay.
I'm interested in, making it complicated is good for us. Or just for us to understand. That the complications exist, that there's no set.
Right.
There's no one thing, because again, you're going to pick up a piece of paper and see if the box is non-payment, all those things that you just described. So
right. It could be a 90-day notice that, they range from 14 to 90 days basically is the notice to vacate periods. Unless I'm forgetting something else. I think that's it. So the other issue that concerns me about the draft is the sealing piece of it. I completely understand that tenants would like their names not to be public so that they don't show up anywhere when a future landlord is looking. And some landlords do, I'm sure, purchase these lists that companies sell where they go and get court records. And Jean, I'm sure, knows more about that from legal aid. But there's no question that it can be a problem. However, sealing is something we do very rarely. Courts are supposed to be open to the public. There's a very strong policy of public access to the courts. We seal juvenile cases and mental health cases basically, are the only closed dockets generally, unless there's a rare exception. And that's for the protection of those people, because of the very sensitive matters that are discussed. I am uncomfortable with the idea of sealing anything in these cases unless at the end the case is dismissed. I think at that point, I would feel that that's appropriate. It protects the tenant from having an eviction on their record. I will say that often those are part of the negotiations, is people negotiate a case if there's a lawyer involved to avoid having an actual formal writ of possession, which is the order saying, tell the sheriff to kick them out at the end of the case, because they don't want that on their record. And also because if you have Section 8 funding, being evicted can, at least in certain categories of Section 8 funding, you can lose your Section 8 if you're evicted. So it is great if they can negotiate something that does not involve that final, order that says you were evicted. And people do that on a regular basis. So the sealing at the end, to me, is sort of the same thing. It would protect them if they were able to get out without being evicted. But it's also, it's a technical pain in the neck to seal individual pieces of a file, which is essentially what I think this proposal is. It's just, blacking out names essentially and addresses and that sort of thing. So I would not, I think it's bad public policy in general. And I don't necessarily think it's fair for the landlords to not be able to check. I will say anecdotally, I've had at least one specific tenant that I remember very clearly who, as far as I can see, makes a policy of traveling around, getting a new apartment, never paying rent, knowing that she can get through maybe 6 months, 9 months before they finally go to court and she gets kicked out. And I've seen her at least 3 times with different landlords. And, that is a minority, absolutely, but we don't want to create a system that makes it easy for someone to do that, in my mind. And, sealing the records would just make that a bigger problem. How would a landlord find out? So just something to be aware of. I think that is pretty much what I wanted to say, except for one passing comment on the housing court idea that is not in here, but you've asked me about separately. I see a specialized court like that is really something for a large urban area where they just have thousands and thousands of cases. I don't see a need for it. I'm not quite sure, what the motivation for it is. I see a couple of problems with it. One is, where would that housing court sit and where would the people have to go? Right now, you get to go to court in the county where you live. And if we had a housing court that was specialized in one location, that creates a question about people having to travel. Yes, we're using remote a lot. It's great and it's wonderful for people who have transportation issues. But my own view is when we're talking about kicking you out of your house, you should have the right to be there in person in court in front of the judge. And it shouldn't be harder for you because the court is in, a different county from where you live. So that's one issue I see with that. I also believe that and I may be misunderstanding what you're thinking of, but if you're talking about a housing court with like a judge who just does housing court, I like having different judges handling the cases because the law develops that way. I rule one way, another judge rules another way. The lawyers can then say, hey, but Judge George, Judge so-and-so said this. And I say, hey, great idea. I hadn't thought of that. And the law develops, and having one person, you lose that. So to me, one of the things about having it everywhere is actually an advantage as opposed to just tracking it down into one person's thinking. But that's a philosophical issue. So any questions, things I haven't covered?
It's financial too, and it's a great philosophical issue, and I appreciate that. This is giving us an opportunity to see how the courts breathe a little bit. As opposed to just thinking that it's somebody up there who's the knowledgeable one. I really appreciate that.
We try to project that image, but we learn from each other.
Question, again, and you can tell me that if it's too complicated for today, but one of the issues that we're dealing with in terms of the impending fears of increasing evictions, especially what we saw with the CRF program and the early VRAP programs were that so many back rent situations were taken care of. So we're down to, we're $3,000 or $4,000 on a more regular basis.
We hope, yes.
Maybe a better number, just to, instead of saying, oh my God, this person owed 18 months worth of, which CRF took care of.
Right.
To the benefit of both the tenant and the property owner. But one of the things we just heard, again, very compelling testimony from folks who were dealing with no cause evictions, which is, and I don't know if this is the place to spend a couple of minutes talking about this from your perspective, because we've heard just cause, we've heard no cause, and while we haven't studied the statute completely, we know that there are many causes for eviction. And then in the non-payment being one of them, committing crimes within the building, damaging things, and landlords in particular have different ideas of what each of those things are. But then we have no cause eviction. And for some, those who experience it, it feels unfair.
Sure.
And I'm just curious if there's anything you can share from your experience seeing. I'm assuming you've seen no cause evictions in court, and how they function. Understanding where they came from is one thing, but just understanding how they function in real time. I mean, again, to hear testimony of people who were just told to leave without knowing anything else about their stories because the landlord was able to use a no cause eviction.
Yeah, so I have definitely seen more because I think property values have gone up and people can charge more and they want to get people out. That is my suspicion. I don't know that. So I have seen an increased number of them, I think, in the last year or so, whenever we started seeing more evictions. I believe my understanding of most no cause statutes that limit no cause evictions is that they usually allow for exceptions such as, and this is true under Section 8 as well as I understand it, for things like, we want a family member to move in there. We want to sell the building. There's already a provision about selling the building, but, I think landlords do have to have the right to get their property back when they want it. And there need to be grounds for them to do that if you're going to start restricting no cause. The way it works now, really the only defense to a no cause eviction is the landlord didn't give you the right notice. That's pretty much it. It could be retaliation, it could be a defense. In most of these cases, I see no defense really ever presented. The landlord shows the right time frame. Sometimes they mess it up. They had to give 90 days, they only gave 60. But other than that, they're pretty much a slam dunk for the landlord when they do it. I think it's really a policy question. You as a committee, the legislature, do we want to say that landlords can't get their property back when they want it? Do we want to have restrictions on it, that they have to maybe give more time to people who are, did nothing wrong? They've made their payments, they've followed the lease. Maybe you want to say they have a longer notice time than currently exists for some of those, just to give them more of a window. But when we hear, get rid of no cause, I don't think it's really completely saying landlords have to keep people in there forever. You have to have exceptions that are reasonable for the landlords to be able to, run their business and use their property. But exactly where those are, I think is really a policy question. I'll enforce whatever you do.
No, that's completely fair. And but again, so many of us here on the committee are new to housing in particular, and housing statute. We all have housing.
Right, I understood what you meant.
But I appreciate that, and I appreciate your testimony thus far.
I would just say, on the rent cases, the non-payment, the defenses are actually I did pay, or they pay up before the end of the case, they're allowed to stay. Or they have defenses like, yeah, I didn't pay rent because the toilet didn't work and the stove didn't work and you wouldn't fix them and so on and so forth. There are various issues, and the retaliation issues about, I reported it to the housing inspector and then they told me I had to leave. So there are more issues that come up in those cases. And then the cause evictions, there are a lot of factual debates often. Yes, I had permission to have the dog, or no, I didn't. And they told me my cousin could stay there. And no, I didn't, break this or that. So there are a lot of issues that can actually lead to a trial and can go either way. The no cause, as I said, it's pretty much, did they give you the right notice period in the statute? And if so, you're probably out. So,
I guess one last, is the CRF money, the impression that I have of the money that was given to us from the federal government in the immediate aftermath of the pandemic, the first slug of money
right.
that allowed for, well, it more easily allowed for communication between the state housing authority or whoever was running the program, between both landlords and tenants, whereas the VRAP money made it very much a tenant, or the tenants had to start the process for the most part of that program. And I'm just wondering if the numbers that we have from legal aid is that we resolved or prevented in 1 year 400 eviction cases. And have you
With those funds.
yeah. And have you, so those are all cases that didn't come into your courts. Is that right?
Is that what that number is? Or is that they came into court, but then they got resolved?
They got resolved.
So, obviously, I don't know about the ones that never came to court, but I will say that a vast number of cases that did come to court have been resolved. We get a stipulation saying, VRAP is paying this much money, we're settling the case done. Vast majority, in my experience. I've been in Rutland and in Burlington during the last few years, so. Did you have your hand up?
I did, thank you. And it was about that, so thank you for circling back to that. When you get those cases, how does that affect the court system and what happens? So does that, because we hear about the overload of the system, there's so many cases, there's not enough time, and so the system is backed up at the extended period of time. So when they go through that, so it's like a 2-part question or 3-part. You said a vast number of them go through that mediation period and they get resolved. So does that mean that they are then dismissed?
Yes.
And so, and in those cases, how does that impact the tenant and the landlord? Is it like it never happened? What happens then?
When you say is that like it never happened, in what
So
context?
how we were talking about the
Like the record?
yes,
Yeah.
yes.
So it varies. Some of those, if you went to look at if you were a landlord and you were going to look at the court file, you would see the parties reached an agreement, everything got paid, and the case was dismissed. Some of them, it will show that they got paid, but the tenant agreed to leave by a certain date. And sometimes that involves an agreement that the court will issue that writ of possession that I mentioned, just in case they don't leave when they said, then the landlord has the sheriff, as a backup. So they vary what you would find in terms of the court record, but it would show, generally it does either show that there was an agreed judgment or the case is being dismissed, one of the two, and those are two different things.
Mm-hmm. Thank you. And so with the diversion program, so back to the question about how does it impact the court?
And our time, for example?
Yes. So do you think that if there were to be a diversion program, I guess that worked sort of in lieu of or advance of the mediation process that you all go through after the notice has been filed? Do you see that would impact the court system in any way, either way?
I'm not sure I completely understand your question, but so obviously it would be advantageous, I think, to everyone, including the court, if there was mediation that could happen before the case ever got filed. That's good for everyone. There's no record for the tenant. Everybody's happy. They reach an agreement. They don't have to pay to file the case. It doesn't take up our docket. So pre-filing is great, but I don't think it should be mandatory. I think it should be available. I don't think you want to require that whole process before someone has the right to come to court. If it's going on during the court process, we actually have something like that now for many civil cases. There's a rule that requires people to add mediation as part of their sort of schedule of how the court process goes. And everything goes along. That's happening at the same time. We may have motions and hearings going on, but there's also that piece of it. These cases that do get resolved with the VRAP money, in my experience, are not actually taking up a lot of court time because the case is filed, it gets served on the tenant, usually by the sheriff. And we might have a rent escrow hearing, those hearings I mentioned before. Typically at that hearing, there's a conversation about they're applying for VRAP funds and, can we wait on issuing this order because they're trying to get the money? And we have those conversations if they're lawyers anyway. But other than that hearing, there usually aren't a lot of hearings after that. If that process is happening, there might be a status conference that's 10 minutes. So I don't see those as a big burden. If that case gets resolved, great. If it doesn't, we might have a trial, but if it's resolved, it hasn't expended a lot of court resources.
Okay.
Did I answer your question?
Did, that was exactly where I was going. So thank you for picking up what I was putting down.
Great. Any other questions I can answer?
Let's go to Judge Sonig. Thank you so much.
You're very welcome.
Thank you so
for
much.
inviting me.
I don't know if there's much for me to say after that.
Oh, you can always think of something to say.
She hit everything.
That was not my place to say the same thing.
Well, good afternoon, Tom Zone, Chief Superior Judge. So when I was listening to Judge Torr and the questions, I think it's important to point out, we're really focused on a problem that is in the state of Vermont. Landlords have properties, they need to rent, they need to get paid. Tenants have properties they need to live in, they need to have the money to pay that. And it's not just about dollars and cents, because as I've testified in many of the different committees here. And what strikes me, and I know that our court administrator, Terry Corsones, is well aware of, because we talk about these types of things, is that it's not just about evictions. Because if someone has housing, it plays into our juvenile court, because it impacts their ability to have their children in DCF involvement. If someone has housing, it may impact down the hall with Chair Emmons and her committee on corrections, because someone may not be getting out of jail because they have nowhere to live. And so housing is one of the most critical aspects of virtually everything we do in the court, because like Newton's third law, for every action, there's an equal and opposite reaction. If Judge Torres, she says, follows that statute that says somebody has to be removed from their home, and they're removed from their home, well, what happens if they have nowhere to live? Does DCF now have to come in and take the children? And then where do the children go? Well, they go into foster care. Well, wait a minute, the parent, the one of them was in jail, and he was supposed to get out, or she was supposed to get out. And so I point this out because we recognize that in the judiciary. And in looking at hearing the cases, this gets to the housing court issue. I agree with Judge Torr that when you look at housing courts, you think of cities. And in fact, if you looked it up online and Googled it, you would see that it says used in large cities usually. And in Massachusetts, I think they have 26,000. I don't know if I can read their data charts right online, but about 26,000 cases they deal with. And then I said, well, what do they talk about in their housing court? What do they do there? Well, they deal evictions, small claims cases, civil actions, including personal injury, property damage, breach of contract, discrimination, as well as code enforcement and appeals of zoning. In many ways, what it sounds like is our civil division. In other words, we actually kind of have a housing court. And it might not be designated as such. We might not have one judge assigned, but we have in 14 counties, each of the clerks setting cases that conform to those green books in Title 12 and Title 9 for statutes as far as how the cases have to be brought in. Because in a landlord-tenant case, there is that ability for a rent escrow hearing. Well, that has timelines. And we in the judiciary are responsible for delivering those timelines, irrespective of all the other pressures. And I would point out, for instance, that right now we are down 4 judges. That means there are 4 positions in the state that we are waiting on the governor to appoint. They are now, the Judicial Nominating Board has sent over names, so the governor will have the ability to appoint. You'll hopefully hear about that coming up in the very near future. But in the interim, where the judges have retired from, we don't have full-time judges. We are covering. And one of those courts, for instance, is Windsor County. And the Windsor Civil Division, we don't have a full-time judge. We have one judge who's coming down, who's currently assigned up in Franklin County, coming down to do certain aspects of cases. We have the Washington County civil judge doing other cases. And what do we have as far as making sure things stay on track with landlord-tenant matters? The criminal judge in Windsor County and the family judge in Windsor County. Each take one day a month, every other week, and do rent escrow hearings. And I point that out because even though we are having difficulty covering all the cases that we need to cover with backlogs and judicial vacancies, housing cases are ones that we are not letting slip through the cracks. We are attempting to make sure Windsor County, again, is an example of keeping things going. It also is important to recognize that the judges who are handling these cases, such as Judge Tour, have ideas. And they're talking whether it's with the Bar Association or talking to legislators about ideas on how we can improve there. And so as we go forward with any questions that you may have, please don't hesitate to let myself know, or certainly Terry Corsones, or if you'd like to hear from some other judges, I can certainly arrange that. But if anyone has any questions, I'd be happy to address them.
You talk about the existing judges will do 1 day a month each, or every other week. Can you talk about, I learned that there's many vocabulary differences between what we know in the court system. Can you tell us what the difference between what a docket is and how a judge would set up a housing docket for a day? Is that what you're talking about?
Well,
docket's a word that I didn't really know.
A docket is an area of a certain case type. So you can set up a housing docket, or for instance, we've heard of treatment court. There's a treatment docket. There's a criminal docket. So a docket is really generally the type of cases that the court will be hearing. The courts have the ability, through working with their clerks, to set up the docket for the cases for housing, for eviction matters. That is something that is done pretty much routinely by the clerks at this point, who work in collaboration with their judges. So the clerks know, okay, we need to bring these cases in our courts at least every 2 weeks because of timelines that are enacted by the legislature. So we try to stay on top of making sure those cases are scheduled there. The judge who's in those courts also has the ability to manage the docket, if you will. And management can be if he or she is sitting in a case and says, wait a minute, we just did the rent escrow hearing, but there's a reason that we need to do this final hearing sooner than waiting several months. The judge can bring it in sooner. Or the judge can say, have you talked about mediation? Have you thought about something? So the judge can manage a case like that also. But the ability of the judge in each of our 14 counties to manage their dockets with their clerks is something that is, it's fluid in some ways, because you might have a month where it's really busy and another month you might not. And you want to make sure that you bring the cases in as you need to.
When we hear about delays, in your experience, where do they come from? Again, we hear from how long the eviction process can possibly be. And I know that in a best case scenario, it could range anywhere between 30 and 90 to 120, depending on where you are. What are the most common delays or reasons for delays in rectifying these cases?
I would actually, that old TV show with Regis Philbin, I would phone a friend on that who's sitting over here. Because I think Judge Tour's experience in the past year is probably better suited to answer that question than my experience from talking to a number of the judges.
Would you like me to answer that?
Sure, just
I think,
you can say so.
I couldn't see you. Some of the delay at the front end is sometimes getting service. So, some cases, the sheriff, I just signed about 4 orders this morning. The sheriff goes to serve the paperwork and the person is hiding behind the counter, behind the curtains, right? There are people who, avoid service. So then the sheriff has to write an affidavit, send it back. The lawyer has to send a motion to me asking, can we tack it on the front door? And I have to decide whether they have enough evidence that that's really going to get the person notice, et cetera. So there's that process. I think how quickly the judge rules on that can also depend on how quickly the staff get it to the judge, which can vary from court to court. I'm sitting in a court that's purely civil right now, and Chittenden Civil, that's all I do. It's much easier to keep things moving than when you're in a court where you're doing juvenile, criminal, family, civil. Things can get more delayed. So how quickly it gets to the judge can be affected by that. And then some of the delays can be in the defendant, the tenant responding So they're supposed to respond within 21 days if they get personally served. Sometimes that doesn't happen, then the landlord files a motion for a default judgment, but then they file their answer. So, they've just paid the lawyer to do this step, but now we are basically required in general to give them an opportunity, even though they're late, to be heard and put on their defense. And then there are motions, right? So then the tenant files a motion to dismiss. I just had one this morning saying, they didn't give me the right notice and they didn't do this, and therefore the whole case should be dismissed. Under the rules, the other side gets 30 days now to respond, the landlord, 30 days to respond to that motion. They might not take it all. Then the tenant has another 14 days to file what's called a reply. So right there, you've got 6 weeks that might go by. Then it goes to the judge. Then how quickly does the judge rule on it? Right. So there are a lot of things that can cause delay, including, okay, now we're ready for trial. I don't have time in my schedule for a month to fit in a whole day trial. You want an hour? I've got it in 2 weeks, but you need a whole day. So there are a lot of reasons. And we try really hard to accommodate these cases. They are things that we treat as expedited compared to other things, like juvenile cases. Those are sort of the two categories. But does that give you an idea of many reasons for delay?
Oh, yeah, thank you. I mean,
Yeah.
that's to hear it in English as opposed to reading the statute.
Right.
And, it's not easy to read the statute. But
I
when you
agree.
Read it. When you do read it and you do see a time frame put out, it's too easy to say it could be as short as this many days if the wind blew correctly and the sun shone on the right trees, et cetera, et cetera. But, I appreciate, this is the real life process on this end. This isn't.
And I appreciate your asking, because I know it's like a whole different language.
Well, it's also, again, we just heard from people who were just living in their cars.
Right.
And how that and one person who had stuff taped to their door, so and they're in this process now. Representative Lamont and Chestnut Tangent.
Oh, thank you. So, when the landlord has 60 days, up to 60 days to file after the notice, was that correct? Has there been instances where the landlord doesn't do that? And what happens then? Because you're just talking about if the tenant, responds late. What happens if that happens on the landlord?
You're looking at me again?
Oh, yeah. You're on a roll.
We don't stop them from filing, but the tenant can raise that as a defense and make a motion to dismiss. I will say it doesn't happen that often. It used to happen a lot when the law first went into effect. I don't see that problem very often anymore. But they are technically entitled to dismissal under, one theory. Some judges might say, well, it's not dismissal. It's, we're going to delay things because you didn't do it right. There are legal arguments that get made over what should happen, but it doesn't come up that often anymore.
Thank you.
So Judge, I was struck by you calling housing the Newton's third law. And also struck by both of you, your empathy for people that you're dealing with who are in difficult straits. I'm thinking that empathy doesn't really work in physics very well.
Correct.
And just wondering, as far as involving DCF or removing children, putting children into custody, how much does the law say you shall, or does the law say you may?
So there's no absolute unequivocal requirement that if DCF says X, you have to put a child into custody. That's certainly, the statutory framework is there for the courts to analyze whether whether the petition provides a basis for finding the merits, but before that, whether it provides a basis for a temporary care order, an emergency care order, or to take a child into custody. When I talk about Newton's third law, it really focuses in my mind on the idea that we have all of these pressures. And Judge Tour, I think, just said it very well, and that is we try to make sure we address these cases. But some days, if you have a judge, for instance, in a single judge county who's hearing a murder case, and the jury is about to get the case, and then something comes in on a landlord-tenant case, they're probably not going to look at that landlord-tenant matter at that moment. And so what we try to do, while we recognize there's an equal and opposite reaction, what we also recognize is we have a group of very dedicated and committed judges. And so our clerks know that, okay, something came in, it's important, we need to deal with it. Judge Torr's on the bench with this case. We can now go to one of the backup judges, and we designate backup judges. And so we can have judges there pick up. We also have retired judges. So if we know that there is a county that has gotten behind for whatever reason on some of their docket, whether it's the eviction docket or family, domestic, juvenile, whatever it may be, we can bring judges in to help out. And so we're trying to do that to alleviate the stress on the system. And that's where it's important for us to have a fully staffed judiciary, having judges and staff to work. It's very important.
Thank you.
Last question for me. The eviction moratorium was in place for just over a year, from April 2020 to July 2021 or something like that. Have you caught up? Has the court system caught up?
Mark, in terms of numbers, Terry Corson, the state court administrator.
Well, actually, Terry, hold on a second.
She's the numbers one.
So she's next up on the list.
Works out.
And are you all set? Do you have
I am.
anything else for us right
And
now?
as I hopefully have noted, we're a team because each of us recognizes that we all bring something, have a different knowledge base. And so if you have a question for myself, if you see me in the hall and say, hey, Judge Zone, if I don't know the answer, I'll get it for you.
So if Helen answers all your questions, whose questions do you answer?
I answer them for the judiciary.
Thank you. All right, Terry, please join us.
Thank you so much for inviting us, Terry Corson, State Court Administrator. And I'll do my best to hopefully just address what has not already been so well covered by Judges Torr and Judge Zone. I thought I might just add a little bit to the rent escrow process that you had asked about before. I'm mainly here to comment on H391 from the impact on the court perspective, what impact it would have on court staff, for example. But I thought I would just kind of explain out, as Judge Teachout said, if there's a notice to vacate that's given and the person doesn't vacate by that date, then it allows them to file an eviction case. And if a motion for a rent escrow hearing is filed at the same time, then typically the larger courts, certainly every 2 weeks, they have rent escrow blocks. Smaller courts, it depends on what comes in, but usually it's within several weeks that a hearing on the rent escrow motion would be held. And that means that, and this is to prevent where if you have a case that might take several months, so that rent comes in during that time, so that there isn't just no rent, during that delay. And this is something that came about from the legislature in 2007, I think, to address it. But at the rent escrow hearing, which is normally held within 2 to 3 weeks after the case is filed, the issue is there rent that hasn't been paid? And if there's rent that hasn't been paid, then there's a requirement that the tenant pay rent into court, that they make those rent payments into court in escrow so that the rent is there, so that when the hearing is eventually scheduled, however many months after that, there's the rent that can be paid and distributed according to however the hearing ends. Now, the rent escrow order that would issue, and I should also mention at the rent escrow hearing stage, it's not at all uncommon for some kind of a settlement to be reached by the parties at that time. And that's where, as Judge Torr said, if there are attorneys there to help with that process, to work out an agreement where they say, okay, I can be out in 3 weeks. Maybe the landlord would forgive the rent that was owed. They have kind of opportunities to address whatever the situation is. But I'm going to guess that it might be even half the time that you might have settlement for rent escrow hearings.
I'm not sure what
probably
the
hard.
numbers are, but there's a good portion.
Yeah, so that's why there are low bono programs in Vermont Legal Aid to provide legal representation to help that process in the hopes that something can be worked out to mutual benefit at that stage. So if a rent escrow order does issue, then saying the tenant shall pay rent into court on this date into the court. If they make the payments into court, everything stays status quo. If they fail to make a rental payment into court on the date that's allowed or that's required, then the landlord has the ability then to ask for a writ of possession. And if the rent isn't paid, then a writ of possession issues, and then there's so many days after the writ of possession is served before the tenant's required to vacate. There's also the possibility for a landlord to ask for a disbursement of rent before the hearing date if there's a hardship that they need to have the rent in advance. So I thought I'd just explain that that's kind of the usual process for the rent escrow. And then the final hearing is scheduled. Again, depending upon the court's scheduling ability, there is a priority given in the hopes that it doesn't, languish indefinitely. So that's just a little more background, just to explain what kind of is happening while the eviction cases are pending. Otherwise, in terms of an impact on the courts, for eviction diversion, the way that this is presently worded, it's pre-filing. So it doesn't impact the courts. There's no case that's filed while most of the activity is happening here. And I think from the court's perspective, where we could be of benefit there is to help publicize that this program, if it comes into effect, is available. And that would be through having materials at the courts or on the judiciary website, whatever way we could help at least publicize, so the landlords and tenants know that it's available. Otherwise, the only aspect of the bill was the sealing provision, which, as it's presently worded, it would say that when an eviction case is filed, right then and there, the court would seal it. And I should mention that actually wouldn't be feasible at present, because there was actually a court case, federal district court, that requires presently all civil filings to be immediately made public. It came out of the e-filing system and delays in processing it. So there was a decision that said there's no clerk review. Once a civil case is filed, a new civil case is filed, it's immediately public. So we wouldn't have the ability to comply with sealing something when it's immediately filed, because right now there's a court ruling that says it's immediately public. The case has actually been appealed and it's scheduled for oral argument in the Second Circuit next week. But right now, I just wanted to alert you to that fact that we really wouldn't, because of that court ruling, have the ability to immediately seal anything. The other aspect.
Just a quick timeout. So Second Circuit is New England, New York, Pennsylvania, or New York, New Jersey?
I don't.
New York, Connecticut, and Vermont.
Yeah, it's just the out of New York.
When we hear that, we heard that from Julio Thompson the other day when we were talking about discrimination law. So the court, that anything that comes up in our district that goes up to the next level before the Supreme Court.
Exactly.
Go to the second district, you'll hear Texas is whatever district, and it's now considered conservative, and San Francisco. I mean, the courts change. It doesn't matter. I mean, whether they're called liberal or conservative, they're just.
Right. We have the U.S. District Court, which is the federal court in Vermont. And if there's an appeal from the U.S. District Court in Vermont, it goes to the Second Circuit, because we're part of the Second Circuit in New York.
Just as a piece of information for us as well.
Right.
Thank you.
So the decision was in the federal district court and it's been appealed to the Second Circuit. So oral arguments are scheduled next week, and so we'll see how many. There's no deadline for when a decision is actually issued, so we'll see.
Okay, so right now that's just, forget the practical part of it from a legal perspective. The sealing upon
Immediate
filing is not allowed.
would be not allowed under this present court case that's under appeal, that we're bound by it unless and until it's reversed or.
Okay. Good to know.
So just to mention that, yeah.
One of the, when we talk about something like this, it's often a place of where would it live, both physically and organizationally. And I'm wondering if it's not a direct correlation at all with small claims, but there's overlap. It's the same kind of diversion from seeking settlement through the small claims has mediation programs usually. Is this something that could potentially be part of small claims or a similar situation? Or are there too few cases to sustain something like that? Throwing a lot of questions at all three of you.
Well, small claims is actually not like just a mediation. Small claims, you file a small claims action and there's a ruling and decision and money damages. It's limited to money cases.
Right. At least there was for a while a focus on trying to mediate small claims.
Yeah, the mediation program has not been in effect for a number of years.
Okay.
You're right, it used to be, but it isn't anymore.
Yeah. In terms of,
A lot of my question right there.
okay, in terms of the numbers in your landlord-tenant cases, in the last fiscal year 2022, there were 1,300 landlord-tenant cases statewide. Fiscal year 2021, when we had the moratorium, there were 400 cases. Prior to that, in the previous 5 to 6 years before then, 2016 to 2019, 2015, 2019, the average was about 1,700 cases per year, landlord-tenant statewide, just to give you an idea.
And that those were cases that were filed, they didn't necessarily result in eviction.
In evictions. It's been, the last fiscal year that I checked, it was roughly half that resulted in, I'm going to say writs of possession.
Sure.
So writ of possession would authorize the landlord to have possession of the property in an eviction order, if you will. So, and I think that's been fairly consistent in terms of the total number of cases and how many result in writs of possession. Okay.
Yeah.
Otherwise, with respect to the sealing provision, the way it's presently written is that once it's filed, and I've explained how we couldn't do it immediately, but it talks about personally identifiable information being sealed. And that, in my mind, for an eviction case, normally it would be the name and the address potentially. You wouldn't have the social security number, bank account number, date of birth, other personally identifiable information normally at play in a landlord-tenant case. So it would be a very cumbersome and very burdensome and very time-consuming process for court staff to redact those identifiers, if you will, in every pleading and every eviction pleading. It really would be a very big burden. And it would be something, as Judge Tor alluded, very inconsistent with general public access to court records rules and theories, where we take pride in having our courts being public, open to the public, publicly accessible. It's only, as Judge Tor said, in the juvenile docket and in the mental health docket that you have confidential records. Otherwise, cases are open. And normally, if you want to seal anything, even an all or a portion of a case, there's an elaborate process through the Public Access to Court Records Rule 9, where you file a motion to seal. There's a notice to the other side. There's a hearing. There's specific criteria as a way to justify why a case would not be public when everything else in the court system is open to the public. So it would be very unusual to have kind of a sealing approach in any kind of case. It's my understanding that nationwide this is being kind of broached or introduced. I'm not aware of any courts otherwise in the country that have what's being proposed here. I understand that the rationale is to protect those tenants, maybe if there's I'm going to say it like a frivolous case, so that you wouldn't have a landlord-tenant case on your record if there was no good reason for it. I think a motion to seal at the end of the case, when that's clear that that's the situation, and there's no reason why a motion to seal couldn't be involved, I don't think, in a landlord-tenant case, as you could in any case. But if it were limited to, as Judge Tor suggested, where a case was dismissed, where it was clear that there hadn't been a writ of possession, for example, issued, or like in a set area of cases, that to me, I think, would be more in keeping with public access to court records policies and in keeping with what's being, I guess, suggested nationwide. And at that point, if there is, for example, a motion to seal, the case was dismissed, and an order to seal, from the court staff perspective, it's much more straightforward, much less time consuming to then seal a case at that time. I mean, it might be a half hour's time to do that versus the time it would take to do what's suggested in this present draft.
Representative Moore.
Thank you. So I'm sorry, I know we're like over. I'll try to be really quick. So, in the event of escrow, so escrow hearings or accounts, is it possible, or is the only way to do an escrow situation with rent for, I'm gonna give an example. If there's a tenant that has uninhabitable living conditions and the landlord is not coming to do you have situations where tenants on their own accord put funds into an escrow account and where so there's sort of a refusal to pay rent, however, it's because of uninhabitable living conditions or some kind of, thing on the landlord's responsibility. And then is that something that happens? Do you see that happen? Is that allowed?
Well, for example, that could be a defense in a rent escrow hearing. There's a rent escrow hearing. The first question is, has there been non-payment of rent? Yes. Is there a defense? I've not paid rent because, and there is a mechanism in the statute that if it's not habitable, the tenant's required to provide notice to the landlord, give them an opportunity to make it habitable. If they don't, then say, okay, I'm withholding rent. So if that's a defense at the rent escrow hearing, it may be that the order is, okay, we're paying rent into escrow then, into the court, not to the landlord, and it will be there until we have a hearing when we can take evidence on whatever the habitability question is, witnesses, whatever the circumstances are. And depending upon the outcome then, if it's decided that, yes, the landlord was, it was not habitable, you were justified in withholding rent, then it would be returned to the tenant, for example, or kind of whatever the outcome was.
And so if it's a situation where the funds were going to things like, let's say it was a lack of heat, for example. And so the funds were then going into alternative methods of heating the home because the furnace was not working and needed to be replaced. Or other, like buying space heaters or other extenuating circumstances that they had to supplement themselves in order to maintain a living situation. How does that play out in that type of situation, or does it? Is that relevant?
The judge would take all that into consideration in his or her order then as to whether or not rent would be escrowed. Or if there was another, depending upon the exact circumstances of that case, what would be fair and equitable. I mean, if it's something that what would go to rent has to go to heat instead, again, the judge would take all the evidence and then issue a ruling. I hope I'm explaining that right. Okay.
Representative Burrows, and then we need to finish up. We can pepper you all with questions all day long.
Well, we really appreciate your interest. It's great that way you all have a body of knowledge to work with to try to evaluate and analyze what would make the best sense.
When you were just talking about the past few years of eviction cases, you said last year, and then you also said 2016, 2019. Was that inclusive of 2016 to 2019 or per year?
For example, 2016, there were 1,690 landlord tenant cases for that fiscal year. 2017, 1,783. 16,
Okay.
17, 18, pre-COVID, it was all about 1,700 a year average.
Okay, and so my next question is, do you track what types of eviction cases there are? Like, do you have a subset of non-payment of rent versus no cause?
We don't, as far as I know, and I would have to research this and get right back to you. It's not typically parsed out. We would, going back, I mean, it'd be very time consuming to check the complaint to see what the allegation was. The one way that made sense to me when I saw 391 trying to figure out how many resulted in eviction notices was how many writs of possession issued, and we could run a report to see that. So there'd be potentially ways, but we don't, as a matter of course, I guess, demarcate what type of eviction case upon filing.
So then I have a question for the judges. Have you noticed an uptick or not in no-cause evictions?
I have. I don't know what the numbers are, but I definitely have felt there have been more since COVID.
Since COVID? Yep.
I also just throw it, if anybody would like to come and watch a morning of rent escrow hearings in my court in Burlington, be in touch and we can tell you when they are. Love to have you.
Or even via WebEx if
Right, you could watch on video, we have.
Oh, yeah, that's a great
I'll put that in my.
offer. More WebEx. No, if we could actually get a breakdown, like I said, of filings. Now I'm curious if I'm getting the vocabulary right, the filings versus the writs. That would be handy for us. Again, this is an issue that we anticipate getting a little thornier when programs end in May and June. And we can make conjecture and we can hear numbers, but I want to just make sure we have some of the best information we can on, I mean, obviously we can't predict the future, but we just want to make sure there's tools in place. And so understanding how these tools get used, that'd be very helpful for us.
I can certainly provide that for these same years.
Great, thank you.
Yeah, I know you're behind, but can I just throw out one other thing? I have never understood why this is, but the law right now says if a writ of possession is issued for non-payment of escrow, the time to leave from service by the sheriff is 5 business days, whereas at the end of the case, it's 14. I have no idea why they're different, but I always feel like 5 days is, I could barely pack up my house then, So you might want to think about the timeframes for the writs in possession, whether they should at least both be the same and whether either one of them should be longer. And I can put the citations in my follow-up to you.
That would be helpful. I can foresee a 17-day, conversation with this would affect.
Yeah, I know.
But I
You should know about it.
No, I think that's really good. Thank you so much for your time. Really appreciate you coming in, and if we do have questions in the next couple of weeks as we work on this bill, we'll be happy, we'll be looking to call the team, and this really forwards our understanding of what we're trying to deal with here quite a bit. So thank you.
And we thank you.
Thank you.
I was going to mention there is that 5-day period too, if it's an unlawful occupant. It's that shorter time frame.
Oh, yeah.
But anyway,
That one I'm not so concerned about.
yeah.
They aren't supposed to be there with it.
Committee, we're going to take 5 minutes, please, so that we can just stretch our legs, and then we have 2 bill introductions, and then we're going to have a third one on S100.